Our first panel set a very high bar, but I'm very confident that our panelists, our speakers on this panel, will more than meet the challenge. I just noticed I haven't been in this building before, and I don't know if it was deliberate that we are here for the Center for Spiritual Life to talk about the rule of law in China, but I think it's appropriate. The previous panel started off with the third plenum. We're going to move into the fourth plenum. And I just want to say one word. People who follow legal developments in China were very excited to hear that the theme for the fourth plenum was going to be the rule of law. As demonstrated by the first panel, as I'm sure all of you know, these annual meetings of the party are historically very significant. They really set out the direction of policy reform. And so when we heard that the theme for the fourth plenum would be the rule of law, it created a tremendous amount of expectations that perhaps it was going to be a watershed event, helping to resolve some of the contradictions between one-party rule and the creation of a society under the rule of law. And we have three panelists who could not be more qualified to talk about whether those expectations were met or disappointed and what the fourth plenum means. So I'll just introduce all of them, even as Nico runs to the back. Their bios are in the material, so I won't go in them in detail, but I think they're all terrific experts. Minxin Pei is a political scientist who has been a great, insightful interpreter of Chinese Communist Party documents and politics. To understand Chinese politics, knowing Chinese language is hardly enough. Understanding how to read Chinese political documents and Chinese politics is really an art, and Minxin Pei is one of the best practitioners we have on this. Don Clark is a professor at George Washington University, but not only a terrific academic who's written about legal developments in China, he's also been a practicing lawyer and has lived through a lot of the legal developments through the reform era, and also coordinates and shares information and really serves as a great clearinghouse for information about the Chinese legal system. Nico Hausen, professor of law at University of Michigan, also deep practice experience in China with capital markets, written about insider trading and regulation of capital markets in China. So I think for this topic, we really couldn't have a better panel. And so without any further ado, I'll turn it over to Minxin Pei.
Thank you. I'm delighted to be here today. I will just give you a very quick overview of what the fourth plenum's reform agenda was and how various specific proposed reforms have been implemented. First, let me just go over very quickly what the Chinese court system is. I will go right away to some of the key institutional problems of China's legal system and how the fourth plenum tries to address those problems. These are the notable features of the legal system, courts. One is it's a very politicized court system, that in a sense that the Communist Party has total control over how the courts constitute and how courts function. It's also a very hierarchical system. It will come as a huge shock to American lawyers and judges that judges are not all equal, because here judges are basically equal. You make make a judgment, and whether you are wrong or not depends on the law, not on your rank, but not in the case of China. It's also a very dependent court. That is, it not only depends on the party per se, it also is dependent on local governments. It's also a very inefficient court. The number is that in Western court, judges actually judge, but in China, only 60% of the judges are involved in adjudication. 40% are involved solely in administrative responsibilities. I have some numbers. It's not as litigious as the U.S., but clearly it's quite. It's a court system that is heavily loaded with court cases, especially in the last few years. You've seen a huge increase in the number of cases filed in the court system. So let me talk about judges specifically, just what's wrong with judges and the courts. One is judges in China do not have real authority in rendering judgments. They have, each court has a trial committee. The ultimate judgments, important judgments, are rendered by the trial committee. And people on that committee are not involved in the actual, or may not be involved in the actual proceedings. And second is that, I've already mentioned this before, key judicial personnel appointed because of political loyalty, not because of professional qualifications. And then courts depend on local governments for personnel appointments and budgets. And that leads to the fourth problem, that is local, so-called local protectionism. Local governments favor local based litigants. I once did a statistical study called Home Court Advantage, which shows that the odds of getting a favorable ruling if you file in your own district is about 75%. So that actually shows when it's above anything above 50% should raise the red flags. And also because of local protectionism, it's quite difficult to enforce judgments in other jurisdictions. And the sixth one is the Chinese legislations are very vague. So they leave a lot of room for interpretation, for political interference, in other words. And finally, local governments are clearly above the law. They just cannot. Local courts are not known to force local governments to abide by the law. So it's also a very corrupt system. I just finished a book which has a chapter on judicial corruption. I have quite a bit of data, but every year you can see, I think in more recent, it's 2,000 some personnel including 806 judges in China the last year were disciplined. Now, the fourth plenum actually flowed from the third plenum. The third plenum had very ambitious, laid out general ambitious reform agenda. I've outlined them here. The fourth plenum simply spelled them out. And before I go into specific proposals, it's a very ambitious agenda. So the first one is that it wants to address very specifically the flaws in China's court system. So it wants to establish a system of accountability, a system of preventing political interference. So the first proposed reform is to recording any form of interference in the court proceeding. And then officials who try to interfere in court proceedings will be held responsible. And the second proposal is to separate, because China's legal jurisdictions and administrative jurisdictions overlap. And that creates problems of local government's interference in the judicial proceedings. So they want to separate. For example, if you live in New York, your administrative jurisdiction is New York, but when a case is tried, it can be tried in Michigan. So it's a very radical thought. And third is that they want, the Supreme Court wants to set up so circuit courts that cover several provinces. Fourth is they want to, again, set up courts and prosecutors' offices that cross jurisdictional boundaries. For example, if you set up a court in Shanghai, that court actually can oversee cases in neighboring provinces. Again, it's all it tries to break down local barriers. And another novel proposal is to set up public interest litigation. The next one is to establish something called judging-centered adjudication system. Because right now, as I said, judges do not make decisions. They want to empower the judges. Once you empower the judges, they also want to hold judges accountable for their decisions. So there will be more transparency in proceedings. One thing they've proposed, which will make judges think twice about rendering a judgment, is that they will be held accountable for their decisions until they die, essentially. Lifelong responsibility, which is a scary thought. But there are also limitations to the proposals. One is that the plan is very explicit about the goal of legal reform. It's not about establishing the rule of law. It is about making the existing system more efficient, more effective. It is not about getting the Communist Party's control out of the legal system. So it's very, very clear. And judges and judicial officers are supposed to be, I'm quoting the exact document, loyal to the party, to the state, to the people, and to the law. And if you pay any attention to this order, you should be very worried, because law is the last element to be loyal to in this reform plan. And the plan also says nothing about how local governments will be bound by the law. If a judgment goes against the local government, how will that be enforced? This is left unstated. And the reform is all about centralization. It's not about really making the system more independent. So management of the court system will be centralized. Well, right now China has decentralized judicial corruption. But are you going to replace decentralized judicial corruption with centralized judicial corruption? So, and holding judges responsible can also be a very bad idea, because it will simply make judges afraid to render a judgment. And recording interference is not going to deliver fundamental improvement, because people can game the system. How do you record the system? A lot of the interference happens not through telephone, through written documents, but through banquets and other things. How can you record these instances? And appointment of judges can still be politicized. So I looked at the progress of how this program has been implemented. They have set up some courts, circuit courts, too, in Shenzhen and Shenyang, at the Supreme Court. These are experiments. They want to see how they work. Second is that they've set up cross-jurisdictional courts, Beijing and Shanghai, that will adjudicate major cases in other jurisdictions, which is a very revolutionary experiment. And special IPR courts set up. That's obviously good news. And 7 provinces have been singled out for localized pilot programs. So I looked at one specific issue. How are they going to select judges? Because selecting judges is a key test. So in Shanghai and Guangdong, these two jurisdictions, these two cities began to implement. And so I looked at the setup. What I found is that this is actually a very cosmetic reform, because half of the judge selection committee are from the old system, and the other half are called experts. The experts are selected by the government, and they are part-time only. So if they use this system, it's not going to actually make a whole lot of difference. So bottom line assessment is that this reform package is the most radical we've seen so far. It addresses many of the well-known problems in the legal system, but it has also severe limitations. And many of the technical provisions contain what I would call bugs, because they need to be worked out. And still, there are a lot of vague provisions. We do not know what they mean. And finally, we should not rule out the adaptive capacity of Chinese officials. If you know anything about Chinese officials, they're extremely clever, but clever in a way that probably a good legal system would not want them to be. Thank you.